next one, it's going to be a whole different conversation.
Is it, do you want to look at this one here, number of citations? Or no, probably not. You probably want to look at this one.
Yeah,
here,
let's
right?
look at this one first. Yeah.
That makes sense. Yeah.
I can do either way. But so what you're looking at, these are the number of cases brought in civil actions. So these are lawsuits to the United States District Courts. These are not the state courts where most cases are brought. This is the U.S. District Courts. And so you have the graph going from 1995 to 2024. It's every other year. So the blank on the far right side is 2024. So that's 30 years. You have 30 years and you're going along 1995, 6, 7. You see, these are all the differences each year. This is difference from, say, average. It's really linear least squares approximation trend line. I don't want to explain that. Let's just say this is the excess cases.
Okay.
In 1995, it's like minus 6,000. Actually, easier for me to read mine. And then 1996 was 13,000, 14 minus 2,000, near zero at 16 cases. And it goes along. So you've got a range from 14,000 at the highest to minus 18,000 at the lowest. And then even in 2019, 10,000. But then in 2020, so COVID hits, right? So COVID comes in 2020, 180,000 more cases than normal. 180,000. How does the court system handle that? If you look at the graph in below, I just used a percentage, okay? Percentage more than expected. And, you've got the most is 5.7% and the least is minus 6.3%. So your range for 25 years, your range is 5.7% max and minus 6.3% deficit. And then all of a sudden you have a 62% increase. That's that 180,000 extra cases. Did you hire 62% more people to handle those cases? No. Did everybody in the court system, all the judges and all the clerks, did they work 62% more hours? Like 14 hours a day, every day for a year? No. There's only one way to do this. You have to start dismissing cases and not hearing them. It's the only way to manage this.
So, John, why are there so many more cases in 2020?
Because of COVID. Everybody was like, you can't do this. You're violating my constitutional rights. You closed my shop. You closed the banks. You closed the roads.
Right. But I'm surprised there were that many civil cases filed. I didn't know that. I wouldn't have. I would have expected an increase, but maybe, I don't know, 20%. But it's 62%.
Yeah, and look at 21. Don't forget. Now, this is what happens with these graphs. When you have something so stark like 2020, it makes 21 and 23 look small, and 21 and 23 are not small. I mean, that's 53,000 extra cases in 2021. Right. So you've got all your vaccine cases, vaccine mandates, everybody's suing. That was in 21. And that's a huge number. 18% increase, like you said, that's a big 18%. I mean, that's more than 3 times more than the prior biggest percent increase. If not for 2020 being so crazy high, 2021 would also look high.
But what happened in 2022? Why is 2022?
Yeah, I don't know.
Such an outlier.
Yeah, it is. I think people get tired. I think they didn't think they had a chance. I don't know. But
this is a really interesting signal. I mean, in 2020, so you had how many cases were these? 180,538. And this is just, who knows how many more people were thinking about filing a lawsuit and then not doing it.
Cornelia, that's excess. The 183,000 is more than normal.
Oh, yeah. You're right. So what's the total? You're absolutely sorry. So what's the total?
I'd have to find the other graph, but it's the other total. It's like, I'm afraid to say it. Well, wait a minute.
But I mean, if it's 62%, it's a 60%. So it must be like 320,000 or some 330,000 or something like that. So it's huge. It's absolutely gigantic. And as I said, who knows how many more people would have done it if the hurdles are. I mean, who's going to just file a civil lawsuit? it's expensive, all sorts of barriers against it, but they did it. So that's a really big signal indicating resistance across the population against what was done to them.
I can prove that many of these cases were unrighteously dismissed, or I can prove that they used dismissal doctrines in the court and civil procedure to never hear the substance of these cases. Let's take a look at the last graph, and I'll show you what I mean.
Okay, let's do that. I just want to point out that we haven't at all talked, but you mentioned it in your book, but we haven't at all talked about the liability shield for the COVID vaccine, so the PREP Act, because it exempts everyone who has anything to do with these COVID shots, the manufacturers, the distributors, the administrators, everyone, from any kind of liability. So you can forget about filing a lawsuit against anyone, really. It's going to be dismissed, so there's no point. But can you imagine if that weren't the case? Well, the whole enterprise would never have got off the ground if there hadn't been this liability shield.
So based on what you just said, let me explain something to the audience. If the first case that comes is solved, then hundreds, if not thousands of cases of the same nature, of the same legal nature, are then not brought because the lawyers know how to advise their clients. We can't bring that. That case was settled. Or we already won. They can't do that to you. I'll write a letter to them. There's no lawsuit. The lawsuits stop when the legal theory is solved at the courts. And because the courts rejected the cases, didn't hear them, dismissed them without hearing them, more people brought more cases. That's what happened. So this is the number of citations by case for the most famous cases in the history of the United States, the most cited cases. The top one is Roe v. Wade, 51,000 citations. Griswold versus Connecticut, 38,000. I'm going to skip a bunch. New York Times v. Sullivan, 34,000. Marbury versus Madison, Judicial Review, 38,000. That case was from 1803. The country was just founded, 1803. Right. Mm-hmm. It's used all over the place. Miranda versus Arizona. Everybody knows you have the right to remain silent. You have the right to an attorney. If you know, that's being Mirandized. That's Miranda versus Arizona. 88,000 citations, 1966. You got the Chevron thing that you've heard about, 43,000. Yep. Lujan versus Defenders of Wildlife is 44,000. That was the seminal case to put a wrapper around what we call standing doctrine. You have to have an injury in fact. It has to be fairly traceable to the actions of the defendant. And the third prong is the court has to have the ability to redress the injury. In other words, if the court can't do anything about the problem, even if you win the case, if the court doesn't have the power to solve the problem, then there's no point in hearing the case. So of those three things, that's Lujan. That was the most famous, 1992. And then you see in the bottom two here, Bell Atlantic versus Twombly in 2007, Ashcroft versus Iqbal in 2009. They're both close to 300,000 citations each.
Wow.
In only the last 16 years.
Okay.
When I do this per year, when I do this on a per year basis, all the bars on the left there, they all shrink. So why is this? Those two cases are only used in dismissal doctrines, such as failure to state a claim upon which relief can be granted, which is lawyer speak that means really nothing. It's not plausible on its face, or you didn't cite enough facts on the face of the complaint, even though Rule 8 says it has to be a short and plain statement showing that the plaintiff is entitled to relief. That's all that Rule 8 says. So this is the courts using these two cases to dismiss any case anytime they want. And so what has happened is that in 2020, they couldn't handle the caseload and they formed habits throughout that year. And if you look at psychology and studies of organizational behavior and habit formation, you have the habit loop formation model. You have conservation of resources, COR, core theory. Conservation of resources means I'm going to conserve my resources and do the least amount of work to get by. And if some negative externality of a whole ton of work comes in, I'm going to figure out a way to get rid of it that conserves my resources the most. I'm not going to work 16 hours a day. I'm still going to work 8 hours a day. I'm just going to write dismiss, 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 dismiss on all the cases, get rid of them. And then there's ecological systems theory. I have all these in a presentation, but just for the audience, these psychological models that have to do with habit formation in an organization and this organizational behavior that happens, they're very, very good. I mean, a lot of people don't like psychology, don't like economics, don't like this kind of stuff, but it's real. You have to admit people form habits. And in 2020, when they started using these two cases, and they were used more, I mean, they were used before COVID, but since COVID came, the courts used these two cases to blow everything out of the water. And
Do you have a graph? Do you have a graph, John, that shows how the citations go up between 2000, let's say 7,
no,
for Bell Atlantic and Ashcroft? Okay.
no, I
But you
don't.
say
I wish I could.
right. Well,
I glean these from Google Scholar. I've since checked it out at Westlaw, and although the numbers are different, they're proportional. So the graph would look exactly the same, but the bottom numbers would be like 380,000 instead of 300,000. But the others would go up too, proportionally. So Westlaw is counting differently than Google Scholar, but the graph is real. I just don't know how to do it over time. I haven't figured out how to do that.
So, what is do you know the approximate percentage of cases that are dismissed?
No.
It must be huge. It must be a huge percentage.
It has to be huge because I did the same graph for the appellate courts, and it doesn't look anything like it. A lot of people are not appealing the decisions, so the appellate courts are not all jammed up. They didn't get as jammed up as the district court. This is a trial courts. You go to have trial, and here's an example, Cornelia. It's not just COVID. You've got a lot of things happening in the United States and around the world. One is climate change. You bring a case, climate change, dismissed. Elections in 2020. 60 cases were brought on behalf of the Trump campaign. 60. All 60 were dismissed without a substantive hearing. They didn't get to discovery. They were dismissed on the procedural stage. And for an example, not only my 3 cases, they used Ashcroft versus Iqbal, right? They used these cases against me in all 3 of the cases I brought. But also from me, little old me, pro se litigant, not a lawyer, representing myself, all the way up to the states, Texas and Missouri brought a case against Pennsylvania for the elections, saying that Pennsylvania broke its own laws. It automatically goes to the Supreme Court because it's 2 states against another state. They call it original jurisdiction. So it goes to the Supreme Court. The Supreme Court said, dismissed, you don't have standing. And they cited Ashcroft versus Iqbal. So not only was it my cases, but all the way up to the president, and 60 cases all dismissed. They all say you don't have standing. So it's elections, it's climate, it's trans in kids, it's COVID vaccines, whatever social issue it is, you don't get any resolution in the courts. The courts are not doing their job of dispute resolution. So what happens, Cornelia, is civil society breaks down. You have people dividing into camps because the issues are not being settled or adjudicated. And so you leave it to society to fight amongst each other, fight on social media, fight in the streets. So we're devolving as a civil society based on what's happened with these 2 cases and the way the courts are operating extremely inefficiently, dismissing righteous cases that should be heard. So anyway, the summation is this graph is the problem with the United States. And everybody's looking at the executive and legislative branches trying to solve it. That's not where the problem is. You can fix those 2 branches if the courts will actually hear the cases. They're not hearing them.
When it comes to the Supreme Court, I mean, the argument that somebody has no standing, when you think, well, obviously they have standing, what are they talking about? That has become more and more, I'm not a lawyer, but just from hearing just recently over the last year, there were some cases that were dismissed on the basis of the plaintiffs having no standing, that didn't make any sense. And actually many lawyers agreed with that. There were articles written about it and lawyers agreed. So if there is this enormous increase in cases that are deemed to have no standing, then you're actually telling or the judicial branch of the government is telling the population that their cases, their problems, their grievances are invalid, don't have to be considered, which is not something that leads to any, as you said, it doesn't lead to resolution, but it leads to a festering. It leads to a festering of problems and grievances within the population, and that never ends well, because that will just fester and grow, and at some point, explode.
We're headed towards civil war. This is what caused it. We can't get resolution in the courts. There's nowhere else to go. The courts refuse to do their jobs. And what I didn't mention here, I could go through the whole history of it back to the Magna Carta, but the First Amendment of the United States Constitution, the last line is you have the right to petition the government for a redress of grievances.
Right.
That is the most foundational right. If you want to uphold your right to freedom to exercise your religion, if you want to uphold your right of freedom of speech, what are you going to do about it? You're going to go to court and sue somebody. And then the court says, nope, you don't have standing. So your foundational right that upholds all others, other than the Second Amendment that we don't want to get to, right? We don't want to talk about violent, using guns to support your right to freedom. But if we set that aside, then the most foundational right before that is the right to petition for redress of grievances and your right to due process of law in the 14th Amendment, equal protections under the 14th Amendment, and your right to dispute resolution in the courts in Article 3, Section 2. The most foundational right you have is being abridged by this idea of standing doctrine that derives authority from this very attenuated path of authority that says Article 3, Section 2 says you have a right to go to court if you have a valid complaint against somebody in another state or if it has to do with a federal law.
Yeah, and John, it's not only abridged by this no standing thing. It's also a lot of the grievances never, maybe even the majority of the grievances never even reach this stage, because if you look at what happened during COVID, the liability shield, so the PREP Act, and also in vaccines in general, the National Vaccine Childhood Injury Act from 1986, they preclude a redress for grievances. You cannot sue for the death of your child, let's say, or injury to yourself or someone else, because of the liability, the freedom from liability.
So many of those that you're talking about are included in this number. People brought those cases, and those cases were dismissed because of the PREP Act. And so those are included here. If, the PREP Act is a whole different discussion. That's highly unconstitutional on its face.
Yeah.
What happened with the PREP Act is that Congress negotiated our rights with an industry, the pharmaceutical industry. They put on the table as a negotiation, a negotiable, our right to sue them. They don't have that right. You can't just pass a law to violate a constitutional right. It's highly unconstitutional. They can't.
Oh yeah, it's totally unconstitutional. But a lot of lawyers will not take these cases anymore. I heard from lawyers who said it's very difficult. People have tried to sue and because of for the COVID vaccines, the death and harm they caused, and all these cases were dismissed because of the PREP Act. So lawyers now say no. If you could go to a lawyer and say I want to sue the government because of what happened to me through the COVID vaccine, they'll say, oh, forget about it. I'm not going to take your case because you're just wasting your time. They're going to dismiss it because of the PREP Act. So, that won't even reach the courts anymore.
So that, I don't know if I told you, but that's why I'm pro se, and my case was dismissed at the district court. The dismissal was affirmed at the First Circuit, and I am currently writing my petition for writ of certiorari at the Supreme Court. I'm trying to go to the Supreme Court. There's a 1 in 1,000 chance they'll take my case, but the graphs that you just saw are part of that, my petition for the Supreme Court to hear my case. And I'm explaining to the Supreme Court, not only did you violate my rights in my case, but this is happening all over the United States, and the United States is falling apart at the seams. Based on these 2 cases, you need to do something about it. You need to fix what you broke. And John Roberts came in 2005 as Chief Justice. Those cases I just showed you were 2 years after he got there and 4 years after he got there. He broke it. His court broke the system. So he's got to fix it, or the United States will devolve into civil war. There's no question about it. I analyzed the medical system and what happened with EBM and everything. It's all about human behavior and behavioral economics. Really, behavioral economics can explain almost everything. And then I turned my attention to the courts and what happened and politics and everything. And like, what is the root cause where if you change something, you can fix the whole system? One of the things that you can fix is standing doctrine. That would fix a lot in the United States. I look for root cause analysis. I do root cause analysis, look for the root causes, and then what can you do to fix the root causes? And in the United States, the root cause of failure of this society is really in the judicial branch, not in the executive and legislative, because you can fix those 2 if you go to the judiciary and adjudicate whether or not a law like the PREP Act is unconstitutional. If I had access to the courts in a real hearing, in a really, objective hearing, then they would absolutely say, yeah, you're right. The Congress can't pass the PREP Act. You can't violate somebody's foundational right because industry needs to make a product. So,
yeah, you're right. Well, good luck with your case. And we'll see what happens. Thank you so much for coming on the show.
Thank you for the interview. Sure. I really appreciate it, Cornelia.